So minor guardianship is a really important tool for many kinship families. What a minor guardianship does is it enables a non-parent to have legal authority with respect to a child who is in their care. And that authority can be important for a number of reasons: for school enrollment, for accessing health care, for making decisions regarding the life of the child, the care of the child, and so forth. And of course, many families are caring for children without having a minor guardianship, but the guardianship can be an important tool when that authority is necessary. Many people also seek guardianship to prevent the child potentially from going into foster care. So if the child is, if they have a legal relationship with the child, the perception is that it's less likely that the Department of Health and Human Services is going to intervene in the family because they see a stable legal relationship between the relative caretaker and the child who is in their care. It doesn't seem to be something that's going to be disrupted or changing anytime soon. So all of those reasons make it very useful for relatives who are taking care of children. The tool is an imperfect fit, though, for what they need. Minor guardianship has been around since Maine's founding, and it's a tool that was originally developed to appoint someone to care for the property of orphans. And we don't have that many orphans anymore. We used to have a lot in the early 19th century when minor guardianship started. But the law really hadn't changed that much over the years, and it was assumed that there really needed to be someone who was just going to step in and assume all of the parental authority that the former parents used to have, now deceased. Today, minor guardianship is being used in situations that are really much more dynamic. They change quite a bit. So very often the child may come into the care of a relative, a grandparent, an aunt, another person, very suddenly, very unexpectedly. And very often the family doesn't know how long that child is going to need to be in their home. And that's because a lot of the circumstances that resulted in the child being in their care themselves are changing. So very often it's because of an illness, substance use disorder, incarceration, poverty, housing instability, any number of circumstances that their parents may find them in. And the parents usually are trying to address those situations as quickly as possible. But very often the parents lack the tools to be able to do so, to be able to get into treatment, to navigate the criminal justice system, to get housing stability. You know, all of the struggles that we see families experience here in Maine can translate into these family situations as well, and affecting the children. And the children need a stable place to live and to be cared for. So the law really wasn't equipped for these types of dynamic situations that families experience today. So the Maine Family Law Advisory Commission, which is a group of judges and attorneys and community members, all appointed by the Maine Supreme Judicial Court, did a study of Maine's minor guardianship law. And they looked at the extent to which the guardianship law really is falling short of serving children, families, and courts in light of the way that the tool is really being used today. So they recommended, and the legislature enacted, a series of changes to the law to really make it fit the situation today. And foremost, or most of all, to give judges more tools to have an order, a guardianship order that's really crafted to meet the needs of the family. The family that's providing the care for the child, for the parents, and for the child themselves.
So they were limited before this law?
They really were limited. The law itself didn't encourage, and in some cases really didn't allow a lot of flexibility in terms of the length of an order, the terms of an order, what the role might be for a parent. It really wasn't set up in a way to facilitate a reunification plan with the parent, or more importantly, to provide some role for engagement with the parent while the child is in the care of a relative caregiver. I mean, the ability for the parent and child to maintain some level of connection, that is the single best predictor of whether there will be a successful reunification. And very often that's what everyone wants, right? The person who's taken, the relative who's taken the child into their home, they didn't necessarily expect to or want to be a parent all over again. They're stepping into the breach to help out when there's a crisis. But the hope is that the child will eventually be able to go back with their parents. And so if there's an order that reflects that, and that reflects what are the parents' particular struggles, are there a way to continue to have contact with the child in a way that's safe, in a way that reflects, the strengths and the challenges that both the parent and the child are having. That's going to really provide a foundation and a pathway for the whole family back to reunification.
So, do you feel like we just talked about we don't know how many numbers are out there?
Yes.
They're concerned. I just had somebody from AFFM say a lot of folks don't pursue anything in court because they're worried about that. How is there protections built in? I guess some protections and things that, to keep them for at least keeping them out of court completely, but they could get the benefit of these tools or these avenues for them to pursue legal guardianship, to give them more rights to advocate for the child.
Right. One of the reasons why people pursue minor guardianship is because they don't know what the alternatives are. Right. They will get advice that what you need to do is you need to go get a guardianship, and they don't realize that there are many other aspects of Maine law that can provide them to advocate and care for children in their care without necessarily getting a guardianship. For example, there are changes that were made to the school enrollment law to allow a child, with the permission of the superintendent, to attend school in the district where they're staying with a relative caregiver, even if their parent lives in another district. Many people don't know that, so you don't necessarily need a guardianship to enroll in a school. There's more flexibility in terms of accessing health care for a child who's in their care. They can act as a surrogate for decision making for that child. So that is
without legal guardianship?
Without legal guardianship, absolutely. I mean,
so
those
were changes in the law that you were the committee recommended and was put into
some of those happened completely separately.
Oh, okay.
They were existing. They were actually
existing,
but not, I would say they're underutilized.
Okay.
They're underutilized. So the school enrollment law, the healthcare surrogate law, and a number of other provisions. So sometimes a full guardianship is not necessary. There's also a part of the probate code that allows a parent to delegate their parental rights to another person for a period of time. And sometimes that's sufficient to meet the family's goals. Mm-hmm. But overall, really what these families need is to be able to sit down with an expert and find what the resources are, someone that they can talk to about their particular situation and what it is that they may need. Do they need a guardianship? If so, they could get some advice about how to go to probate court and petition for guardianship. Do they need a full guardianship? Maybe they just need a limited guardianship. Maybe they need a short-term guardianship, for example, while a parent is serving a prison term, and then that guardianship would end. In many situations, it's appropriate for the parent and the relative caregiver to be co-guardians, so that they can, in some ways, really share the parenting of that child. Again, maintaining that connection between the parent and child, even if the parent is serving a prison sentence, getting some much-needed substance use treatment. Something along those lines. It's one of the reasons why the Kinship Advisory Group recommended, and the legislature has given at least initial approval to the idea of a Kinship Navigator. Mm-hmm. Kinship Navigator program is in many states across the country, and that can be a really key resource, one-stop shopping for someone to get advice and information and guidance about how best to make sure that the child is getting their needs met, even if they're not in the care of a parent.
Is that so? They've approved the funding. I understand. Which I
think they
with Charlotte Morin.
Yeah.
I was just trying to find out more because I know they had carried. Did
they carried it over?
Right.
It's on the appropriations table, is my understanding. So they approved the bill itself,
okay.
But the bill has a fiscal note.
Oh, I see. So they have to find the money.
They have to find the money,
but
and I hope
really
they do.
Key to opening up that.
It's money well spent. It's absolutely money well spent.
Since you're a legal expert too, I've been doing some research on some of the cases. Like in Ohio, there was actually a lawsuit that made the system more equitable between kinship families, and so they're going to be getting that financial benefit. Could we see that here in Maine eventually? Because some of the federal dollars that are coming down from the Family First Initiative, that's more prevention services, we're not really looking at equaling the playing field, so to speak, but it took a lawsuit in some other states, I think Kentucky's also in there, Could we see that here in Maine eventually?
That's the hope. I mean, I think that wise policy would put more resources towards prevention, and kinship families are an indispensable part of prevention efforts for all of the reasons that we've been talking about. Sometimes a child needs to be in the care of a relative while a parent addresses the concerns that brought the family to the attention of the department in the first place. And then rather than the department sort of sweeping in and bringing a court order and removing the child and potentially putting the child in foster care, there's no guarantee that the child's going to be placed in the kinship placement. If they can devote some resources to helping the family with what they need ahead of time, including a kinship caregiver, then they may prevent the need to have a court case at all. They may prevent the need for there to be foster care and all the uncertainty and all the trauma to the child that foster care can involve.
I mean, you're saying some really good points, but do you see that eventually happening? That, again, I was doing the research on Ohio. Their payments are the same now.
Yeah.
They're going to be equal with licensed foster caregivers, and they were able to take that step. Again, it's a different system, different things going on. I mean, it's not really on the table anywhere. I talked to some lawmakers. Unfortunately, they're waiting to see if they can get waivers and maybe use some of this federal funding that's coming down.
Yeah, I mean, the law is very new. The federal law is very new and in some ways was unexpected. And I think we're all waiting to see if it could deliver on the promise. I mean, I'm already certainly, hearing from some advocates around the country concerned that it really won't be able to deliver on the promise. I mean, the policy statement that accompanied the Family's First Law sounds wonderful, but it will require dollars to back it up. It will require federal dollars. It will require state dollars. It's money well spent, but as is often the case with public funds, it's not always easy to see the initial investment. And the more that we can shift our investment into these prevention efforts rather than, incredibly cost demanding, and it's cost not only in terms of dollars, but again, in terms of the lives of these children, the families that are affected, I think that would be appropriate. The problem is our mindset. For so many decades, we have been really focusing on child removal as being the primary child protection policy, and it really needs a reorientation, and that's one of the reasons why I think it's wonderful for there to be increased kinship placement is that the child protection experts themselves can see the benefits. And I think they do here in Maine. They can see the benefits, the different outcomes for children if they have the opportunity to stay with their siblings, if they have the opportunity to stay with a relative or another, someone that they already know and they don't have the trauma.
Prioritizes family placement
they
first,
do.
Right?
Yeah, absolutely.
Even in those situations, they do that. That's kind of in their policy.
Yeah, and then they take that one step further, right? And being able to provide resources to the families so that really the department does not need to intervene at all, other than perhaps providing the services that are necessary so that the family really can stay together. It doesn't take a kinship placement, which happens after a forced removal. And even that in itself can be disruptive for the entire family, and there's the uncertainty that's involved with that.
Is there one state or several states that you've looked at as setting a precedent that's really getting it right, you feel, that are really doing, like you said, more on the front loading versus on the reactionary?
Yeah.
Can you talk about
I can't really point to one right now.
Okay.
It's a good question, but yeah, I haven't. I mean, I see like lots of little things around the country. I mean, I think I think the states that provide subsidized guardianship across a broader number of families, that's key. The states that have provided kinship navigators, those are the elements of, and that lower barriers to access to substance use treatment, to housing, to other types of upstream interventions for families. Those are the ones that are ultimately going to be successful in outcomes for children.